The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to today's hearing on oversight of the United States Citizenship and Immigration Services. I'll begin by recognizing myself for an opening statement. I first want to welcome our witness, Mr. Rodriguez. U.S. Citizenship and Immigration Services, USCIS for short, is responsible for processing over 6 million immigration benefit applications per year, as well as implementing programs important to immigration enforcement such as E-Verify and the Systematic Alien Verification for Entitlements program, also known as SAVE. Even without concerns being raised about terrorists seeking to exploit our refugee program or other aspects of our immigration system to enter the United States, processing such large numbers of immigration benefits applications would be a daunting task. But those concerns are being raised, and they are on the forefront of my fellow citizens' minds. And as a result, I look forward to hearing what changes, if any, Director Rodriguez has or will soon implement at USCIS to help ensure terrorists are not approved for visas or other immigration benefits. Many of the people I work for are particularly concerned about the prospect of a terrorist being resettled in our communities through the U.S. Refugee Admissions Program. And while I know we discussed this very issue weeks ago in the subcommittee, those concerns are not going away. We are still looking for assurances the refugee program vetting is secure and effective. Our concerns were only exacerbated by the remarks of our colleague, Homeland Security Chairman Mike McCall, indicating efforts to enter our country via fraud. The refugee program are currently, emphasize currently, occurring. Aside from security vetting concerns, fraud is always a problem in immigration benefits processing. I know the current and former directors of USCIS have come before this committee and said how fraud detection is a #1 priority, but that is difficult to reconcile when we consistently hear from sources within USCIS that leadership will not pursue anti-fraud technology, that rubber stamping of benefits applications is encouraged and even in some instances forced, and that USCIS's own anti-fraud unit, the Fraud Detection and National Security Directorate, is routinely sidelined and underutilized. My constituents are proud that the United States has the most generous immigration policy in the world. And they are proud that the United States is a beacon of hope for foreign nationals seeking a better life. But they have a right to know that the immigration programs are being run in a manner that does not put them in danger. And right now, they don't feel that way. That is not to say that there is not some good news coming out of USCIS. The bright spot seems to be that E-Verify program, use of which by employers is growing, and which has had an extremely high successful verification rate. So I want to thank Director Rodriguez for his continued support of the E-Verify program, and I look forward to his testimony today. With that, I would recognize the gentlelady from California, Ms. Lofgren.
Thank you, Mr. Chairman and Director Rodriguez. It's good to see you here again. Welcome to the Immigration Subcommittee. I'm sure we will hear from you to the extent you're able to discuss security measures taken by the agency, especially in light of the news coming out of San Bernardino in my state. So I'm going to focus on other elements that are part of your important mission. As we know, a year ago, Secretary Johnson issued a series of directives, 2 of which have been held up in a dispute with Republican governors. I won't address that because the Supreme Court is going to do so. I'd like to talk about some of the issues that were not the subject of the litigation, specifically the parole program for immigrant entrepreneurs. You know, one of the things that keeps our country ahead of the game economically is the tech sector. And we have failed in our necessary effort to reform the immigration laws, which is really the result that is necessary. But the President was trying to think, and Secretary Johnson was trying to think about things that could be done consistent with the current law that would make the economy work better. And one of the things was that parole program for immigrant entrepreneurs. Now, a lot of companies that are household names are right in my neighborhood. Intel, Google, Yahoo, eBay, et cetera, were founded by innovative immigrants. They now employ tens of thousands of people. And according to new research, immigrants have created half of America's top venture-backed companies. And those companies in turn have created an average of 150 jobs each. And of course, when you look at some of them like Google, it's tens of thousands. So I'm concerned that we haven't launched the entrepreneur program. I'm eager to know where that stands, and maybe you'll be able to address it. I just want to touch on an action that I found gravely disappointing, and I realize it was not primarily the USCIS, but that was the October visa bulletin that was mistaken. Many people, immigrants, relied on the bulletin, as is reasonable to do, to their detriment. For example, I met personally with an individual who is a postdoc doing cutting-edge neuroscience research funded by the federal government, funded by the NIH. He was going to file for his permanent residence based on the priority date. He did not renew his H-1B visa. Then the visa bulletin was amended, and he's nowhere. He's nowhere. It's crazy that someone who's been here for years, who we're funding, who may get a Nobel Prize, is just nowhere. And so I don't know how many people like him were disadvantaged, but I'm wondering what efforts the agency has thought about just to ameliorate the harm done by that mistake in the bulletin. I am concerned that the program really set up to avoid the rush of refugees across our border who've come through Mexico fleeing violence. The alternative to process refugee applications in country has not really worked. I don't think any child has been admitted yet, and I'm concerned whatever light you can put on that situation, I would appreciate knowing. And I also would like an update on the technology efforts that the agency has been making. When the president was elected, we were almost entirely paper-based, and I think we've made some progress, but not as much as I expected or hoped that we would. And I'm hoping that we'll be able to give us, you know, if you've got a FedEx package, you can track where it is. You know, if you're expecting delivery, we haven't been able to deliver that kind of customer service, and I think the American public would be better served if we could. So anything you can give us on those lights, and I know that you will talk about the security issues that the chairman has also touched on. With that, Mr. Chairman, I see my time is about to expire.
Gentlelady yields back. We are pleased to welcome our distinguished witness today. Director, if you would please rise and allow me to administer the oath. Thank you, sir. Do you swear the testimony you're about to give is true, the whole truth, nothing but the truth, so help you God? May the record reflect the witness answered in the affirmative. Director, you have a long and distinguished career as a prosecutor, which I am going to give short shrift to in my introduction, so forgive me for that. But today's witness is the Director of United States Citizenship and Immigration Services. He was sworn in as Director on July 9, 2014. He previously served as the Director of the Office of Civil Rights at the Department of Health and Human Services, a position he held from 2011 to 2014. From 2010 to 2011, he was Chief of Staff and Deputy Assistant Attorney General for Civil Rights at the Department of Justice. He received a BA from Brown University and a JD from Boston College Law School. As I mentioned to you beforehand, I think you prosecuted in about every level that one can possibly prosecute at. So thank you for your service to our country. And with that, I would recognize you for your opening statement.
Thank you, Chairman. It's great to be here in front of the committee today and to address the myriad of issues that both you, Chair, and Ranking Member Lofgren have raised during your own opening remarks. I had planned to, in my opening remarks, to discuss my own broad priorities for USCIS, specifically to fully and effectively implement the executive actions to effectively and safely process our refugees, to continue to advance our transformation process, and to continue to maintain a high level of customer service and stakeholder engagement. However, the recent mass murder in San Bernardino, California, near Ms. Lofgren's district, and a number of recent events, I think, as the chairman pointed out, make it particularly important that we talk about security issues here this afternoon. I would note at the outset two things. One, I will not, unfortunately, have the luxury to be able to talk about specific cases. Some of these are cases under law enforcement investigation. In any event, there are privacy policies and laws that apply to specific files. Two, I would observe that after nearly a quarter century in and around law enforcement, one of the things that I've learned very much through personal experience is that violent criminals can come from pretty much any faith, any nationality. They can be U.S. born, they can be immigrants, they can come from just about anywhere. My particular role, our particular role in USCIS is to ensure that those who seek the privilege of admission to the United States, be they as travelers or as immigrants, that they in fact be individuals who deserve that privilege, that they not be individuals who either intend our nation harm or who intend to become criminals when they come here to the United States. And we have been working diligently in recent years to enhance our ability to weed out both individuals who are criminals and who are threats to our national security. And to give some examples of the kinds of things that we do, we have enhanced the resources against which we vet all immigrants, not just refugees, but also all immigrants. We have developed improved techniques for fraud detection, for interviewing in order to advance that. Now, in light of the events in San Bernardino, the President and the Secretary have both directed USCIS to review both the K-1 visa program as a whole, which we are in the process of doing right now, but also to do a retrospective look at cases approved in recent years under the K-1 visa program. And we are fully along in conducting that effort. I remain mindful, however, that our charge in USCIS is really to look at the security of our entire process. So while we are focusing on K-1 today, I want to make clear to this committee and importantly also to the American public that our focus will be across all of our lines of business to ensure that bad guys do not gain admission to the United States. I am blessed at USCIS with a tremendous staff who is dedicated both to following the law, to serving the American people, and importantly, to preventing fraud and threats to our national security. As a couple of examples of the kinds of things that we've done, in light of concerns about our asylum program, we have been increasing the presence of fraud detection and national security officers in our asylum officers. We've doubled the number of those individuals in recent years. Similarly, in the EB-5 program, we have doubled the number of fraud detection and national security officers there as well. There are many other topics that I would like to address, and hopefully through questioning I will have the opportunity to address a number of the issues that Ranking Member Lofgren raised. But I'd like to conclude with this observation. I read something in the paper just a few days ago that really rang of truth to me. And that was the notion that the worst thing that we can do to the terrorists that wish us harm, the terrorists who are trying to recruit others to harm us, is to continue to be a beacon to people throughout the world. The fact that many of the very same people who those terrorists would like to recruit, in fact, are seeking admission to the United States is the most severe indictment of what they are trying to do. That inspires me as much as anything else to do the work that I do as USCIS Director. Thank you, Chairman, for having me here today.
Thank you, Director. I'll recognize myself for 5 minutes of questioning. Director, I'm going to make a series of what I think are factually supported assertions. If any of the assertions are incorrect, I want you to correct them because hypotheticals or realities are no good if there's an incorrect factual assertion. So it appears as if the female terrorist in California entered the United States in July of 2014 on a K visa. And there's an application process which includes some level of investigation on our end. And as I understand the application process, it may well be that USCIS and the State Department have some level of engagement, at least at the application process. And then, as I understand it, there is or is supposed to be an in-person interview at an embassy or a consulate, which is another level of investigation. So you have the application, which may involve USCIS and the State Department, and then you have an in-person interview. And the way I count, that's at least 2 and maybe more levels of inquiry or investigation. And then we fast forward, the FBI director today, I believe, tells us that there is evidence that the female terrorist was radicalized 2 years ago. And there's a media account, and you are free to put whatever stock you would like in a media account, but it's been widely reported that the male terrorist was part of a plot in 2012 to do harm in this country. So it appears to me that the investigations done by our government would have occurred after both her radicalization and after his previous plot to commit an act of terror. And yet the visa was approved. And she immigrated here, and 14 body bags later, we are trying to figure out what went wrong. So, assume arguendo that the FBI is right, which is not an unreasonable assumption. The female terrorist was radicalized well before her application to come to the United States. How did we miss that twice?
So again, I will take that question as a hypothetical, given my inability to speak to the specific factual scenario. I think in addition to the interviews that you described, individuals are also vetted against law enforcement and intelligence databases at multiple stages in the K-1 visa process. So when we adjudicate the petition by the U.S.-based person, usually the fiance on our side of the ocean, there is a series of background checks done at that time. The State Department does another more fulsome series of checks, and then we see that individual then again at the time of adjustment once they are in the United States. The nature of the interview depends on what derogatory information we have about the individual. So in the absence of a specific we ask a series of questions that obviously are intended to vet that individual out, but in the absence of a specific basis, we probe basically the record that is before us. One of the things that we are looking at right now, and again, I think about this not just in terms of the fiancé visa program, but I really think of it in terms of everything that we do. Are there things that we need to be doing differently prospectively to probe even more deeply to ensure that we are not admitting individuals who will come here to do us harm?
I wholeheartedly concur that we should be looking at all visas no matter what letter occurs in front of them. It just so happens that this is a K visa, but the analysis could very well be the same regardless of what kind of visa it was. And what I'm not trying to put words in your mouth, but what I hear you saying is we don't know if anything would have been done differently, and it's a thorough investigation, and yet we still missed it, which tells me that I have to go back to South Carolina and tell people there's just going to be an error rate.
Well, you know, one of the issues that we're looking at are what are our authorities at different points in the process. So, for example, at the point when we adjudicate the petition, as it stands right now, as long as the bona fides of the petition are established by the U.S.-based petitioner, regardless of what derogatory information may exist against that individual, we don't at that. And again, I'm talking generally. I'm not talking about this any specific case. That is certainly an issue we're looking at as to whether we need to think differently about what we do in that stage of the process. We're also looking at what we do on the back end of the process at the time when we actually give that person a green card, or we give them a conditional green card. Are there additional measures we need to be taking at that stage as well?
Director, do you know whether or not the female terrorist in California was interviewed in person at an embassy or a consular post?
Again, respectfully, Chairman, I am not at liberty in this setting to talk about any specific. Now, I can tell you what our practice is. Generally, there have been exceptions to this. Generally, it is our protocol that we do not, we only interview people in the K-1 visa program in cases where there is some issue that needs to be explored as part of the case. That could be derogatory information about the individual. It could be factual questions, not necessarily derogatory about the application. That is the existing practice as we speak. That's certainly going to be part of our review.
Do you know how long the investigation lasted from the time she applied for a K visa until the time she was interviewed at whatever consular post or embassy?
Again, I am not at liberty to discuss a particular case. That can be from the time they get in. If I'm understanding the question, from the time they're interviewed at the consular post to the time that we adjust them. Is that the question, sir?
I was more interested in from the time she applied until the time there was whatever first interview, whether or not there was research done into her school, if any, attended, social media, if any, employment history, if any, and I'm out of time, so I'm going to go to the general lady, and I'll give her exactly the same amount of time I took. I'll just tell you this, I appreciate, because I hear it a lot from administration folks, that they cannot discuss an ongoing investigation. I would just note the obvious. They're dead. So I don't know that we're terribly worried about their privacy considerations. And I'm not lodging this allegation at you specifically. I can just tell you, I've been around 5 years now, and it just strikes me that sometimes folks cite an ongoing investigation or prosecution when they just really would prefer not to answer the question, because there's not going to be a prosecution of either one of these terrorists. You and I agree on that. So I'm not sure what we're worried about jeopardizing by allowing Congress to look at her file. What investigative or prosecutorial strategy would be jeopardized by allowing Ms. Lofgren and I to look at her immigration file?
Again, I'm really citing the general practices in rules. I mean, I think you and I are both aware of cases where, in fact, regardless of the fact that there may be two dead perpetrators, where there are still actually investigative reasons to maintain secrecy. I'm not speaking necessarily to this specific case. That is the practice that I have lived by, be it in my role as USCIS director or when I was a prosecutor previously, that I did not talk about cases that were ongoing, regardless of those characteristics. I understand why this body would want them. I understand why that information might be helpful to this body in discharging its responsibilities. I do not see myself as at liberty to share that information at this time.
Chair will now recognize the gentlelady from California.
Thank you, Mr. Chairman. Just picking up where the chairman has left off, I'll disclose that my office did call over and ask for a copy of the K-1 application, and we were advised that it was the FBI who has said, really, this needs to remain confidential at this point because of their investigation, and I accept that. You know, I want the FBI to be able to do everything it's supposed to do. When they're done, however, I want to take a look at all of it. And so I think how long that investigation will take, none of us can know, but I know that the chairman, I'm sure, would share my desire that once it's over, let's take a look at all of it. We wouldn't want to jeopardize the ongoing investigation. In terms of what USCIS does, the interview for, and not talking about this case, but just how one obtains a non-immigrant visa, be it K-1 or H-1B or whatever, the applicant applies abroad, and it isn't USCIS that does the interview, it's the State Department, isn't it?
Yeah, that's correct. All we do at that stage is adjudicate the bona fides of the petition here, meaning the bona fides of the relationship. The actual interview, the actual screening is conducted by the State Department at a consular post overseas.
And you're not a law enforcement agency per se. What you're doing in terms of the criminal element and checking it out is checking with the FBI and the database and the like to see what comes up. Isn't that right?
That is correct. I will amend that to say we do see ourselves as having both a national security and law enforcement responsibility.
Yes.
To ensure that people who trip either of those wires are.
Of course, but you don't have an
of course.
army of agents as a law enforcement agency. You rely on the FBI
Not
to
in,
do
no,
that.
no, nobody on my staff carries guns as part of their job.
All right. So in terms of if a person comes over on a K-1 visa, say, they have 90 days in which to get married to the American who's petitioned for them. What happens then?
At that point, I believe they have 120 days. Once the individual is here, they have 120 days within which to seek adjustment, which in the ordinary course most people actually do. At that point, they become essentially a conditional permanent residence, and I apologize, I don't know the exact duration. I think
No, it's
2 years is
conditional, and the
duration of
marriage
that.
has to
Yeah.
prove valid.
Yes.
And after 2 years, then the couple goes in and they apply to remove the condition because they're still married. It's a valid marriage. Is that correct?
Correct, yes.
So at that point, you are still interviewing to make sure that there's nothing that you can discover that's fraudulent or wrong, aren't you?
We're both interviewing and also running additional checks, of the kind that have frequently discussed before this committee. We're doing additional checks on those individuals.
And so if somebody came on any kind of visa like that, there's, many, many grounds for inadmission to the United States, whether or not you're married to an American or a fiancé. I mean, if you have committed drug smuggling or if you are a human trafficker, you're not admissible to the United States, no matter what. If you're intending to commit a crime in the U.S. or you have terrorist ties, you're not admissible to the United States.
If there are, that is correct, if there are indications that you are a criminal or that you are intending to immigrate or travel to the United States to commit a crime, then that would be.
So the real question is not whether or not the law needs to be changed. That is the law. It's a matter of how that information is discovered and by whom.
Correct, one of the issues that we're looking at is our authority at different points in the process, in addition to our practices at different point in the process, to ensure that we are trapping those issues at every opportunity that we can.
I'm going to switch to another subject. After there was a report, both in Disney and Southern California Edison, who were using the H-1B program to replace U.S. workers. It was pretty outrageous reports. And Secretary Johnson described it, and I quote, as a very serious failing of the H-1B program, and that Congress could help put an end to this through increased enforcement mechanism for situations where an employer does in fact replace American workers with H-1B visa holders. What type of enforcement mechanisms do you think are needed to ensure that the H-1B program is not used to displace American workers?
So I think this is an area where we would be very happy to work with this committee to provide technical assistance. I think one of the issues to which you're speaking, one that I was very interested to learn as I was digging into the H-1B process, is that you can accomplish a certain result through contractors that you couldn't necessarily accomplish directly. And that's certainly a discussion that we'd be happy to have with this committee as a technical assistance matter.
Well, we may take you, I've got some ideas on that as well. I mean, some of it is regulatory, but some of it is economic. And we might change the utility of that method through just the economic parameters of the program. You know, I want to touch just, and I know we're over, but the chairman said I got the same amount of time, so I want to talk about the Special Immigrant Juvenile Program. As we know, this has been, this category has been in the law since 1990, and it provides protection to children who essentially have been abandoned by their parents. The juvenile court in the given state is the one that makes that determination on whether the child before the state court is, has been in fact abandoned. Now, although your agency is charged with fraud, combating fraud, I'm hearing reports that your adjudicators are seeking evidence to essentially to collaterally attack the decisions that have been made by state courts about dependency. And I'm wondering, absent information about specific fraud, would that be something your agency should do? And what would be the legal basis for a collateral attack on a state court determination of juvenile dependency?
Yeah, the concerns about our examination of state court findings are issues that have been raised to us frequently by stakeholders. As a former county attorney, I actually come with the background of having represented a child welfare agency myself, so I understand this process pretty well. Those inquiries by our staff members are not meant as collateral attacks, but they occur in circumstances where the order issued by the family court or the juvenile court or whatever the court of jurisdiction may be does not satisfy on its face the requirements of the law. It doesn't, in essence, it doesn't say everything that it needs to say in order to qualify under the special immigrant juvenile. It is at that point that our officers are asked to look further to ensure that those elements are established.
That's very helpful information. I see my time has expired, Mr. Chairman. I yield back.
Gentlelady yields back. Director Rodriguez, I'm at the end of this, I'm going to make sure that Congresswoman has exactly the same amount of time I have. It's just if I don't ask this question now, I probably will forget to ask it before I go to Chairman Smith, which is this, something she said prompted me to want to ask this. It strikes me that there are at least two things we could say to our fellow citizens, one of which is we missed it as it relates to the female terrorists, and that's just a risk that we're going to have to accept as an open society. The other alternative is to say this is what we've learned from that fact pattern, and this is what we're doing differently to prevent the next one. Which is it, and what assurances could you give that we are going to do it differently so there is not a repeat of this fact pattern?
Again, I think the point that I made earlier was we're looking at everything. In other words, we're looking at cases that may have happened today, and we're looking at all the issues related to where we can do our job better and make sure that to the extent of our ability, we're never going to eliminate all risk, but to the extent of our ability and the resources that we have, that we reduce risk to the greatest extent possible. That is a commitment that I make to the American people. That is the purpose of having me as a former prosecutor as the head of the agency, is to really press us to not miss those opportunities to do better and to keep the American people safer.
The chair recognizes the gentleman from the great state of Texas, Chairman Smith.
Thank you, Mr. Chairman. Director Rodriguez, it seems to me that the President's words and actions are having an unfortunate impact on both immigration levels and on immigration policy. For example, the President's proposed amnesty led to a surge last year in illegal immigrants coming from Central America, and we're seeing a similar surge today. The President's proposed changes in our Cuban policies have led to a recent surge in Cubans, particularly coming across our southern border. Now, they are not illegal immigrants, but the point is that it's led to a surge as a result of his policies. Because of this administration's lack of enforcing current laws, the number of sanctuary cities has doubled under this administration. All that is worrisome to me. as is the administration's policy towards Syrian refugees, which is what I want to ask you about. In regard to those applying for asylum from Syria, do you feel that we are able to get as much information about their backgrounds as we are applicants for asylum from other countries?
I think we do have. It's very hard to compare because I think it would be easier to take two cases and compare two cases. I think comparing one broad body of individuals to another broad body or different nationalities, I think, is a different kind of scenario.
But you say generally you think we're getting as much information and there's as much data?
I think we are getting a lot of information that is useful, that enables us in particular cases to deny individuals applications for refugee status, to put questionable cases on hold. I don't feel able to engage in the kind of comparison that you're inviting me to.
Okay. Well, you initially said you thought we were getting the same. You're aware, of course, of the FBI director saying that we are not getting the same amount of data on Syrian refugees as we are other individuals.
Are
you aware that the director of FBI said that?
Oh, yeah, no, I'm aware of that. And if I may, Congressman, I think the main comparison that was being made, and it's a hard comparison to argue with, is that we're not in Syria. We don't have boots on the ground in Syria.
Right.
We did have boots on the ground in Iraq. That doesn't mean that we're blind.
No, I'm not implying that. The director of FBI said, my concern about bringing Syrian refugees in the United States is that there are certain gaps I don't want to talk about publicly in the data available to us. As a result of that, do you think it is more risky to admit individuals from Syria than other countries because we don't have as much information, or do you think there's no more risk involved in admitting individuals from Syria?
There is risk in our business.
That wasn't my question. I wasn't asking you about general risk. I was asking you specifically, is it riskier to admit individuals applying for asylum from Syria than from other countries?
I think individuals who come from places where terrorists are active, where terrorists are seeking to recruit, command from us a higher level of scrutiny. That is why Syrian refugees in particular receive the most, the toughest, most
I understand
rigorous
that, but
we do.
that doesn't count for anything if there's no information available. If you don't have good data, you don't have a good result, no matter how good the process is. I'm not questioning the process.
But that's the point I'm trying to make through concrete example. We have denied people admission because of information that we learned from law enforcement.
Is your denial rate for those applying for refugee status from Syria a higher denial rate than other countries? And if so, what is the rate?
Well, I think the denial rate is a deceptive statistic, and I will tell you why. It is very easy to demonstrate a claim for refugee status in Syria. Syria is a mess. There is all kinds of sectarian violence, violence based on political opinion. Yeah. So it would be very hard not to establish a claim for refugee status. The question is the individual inadmissible because they are a terrorist or a criminal?
What was the answer to my question? What is the denial rate for those applying from Syria versus the denial rate for those applying from other countries?
At this point, I believe it is approximately 20%.
20% denial?
Yeah, of the group that we've admitted so far. In other words, there are a number of individuals in the pipeline, so that rate could shift.
So you admit 80% of the refugees from Syria?
Given the very small pool that we've seen so far. In other words, I don't think that necessarily speaks to what our rates are going to be.
Okay, it seems to me that's, for a group that seems to be riskier in a group on which you have less information than those applying for refugee status from other countries, it seems to me that that's a dangerously high admission rate.
Yeah, actually, and let me correct that. That is a rate of non-admission. In other words, those could be individuals who have either been outright denied or who are on hold.
Understand.
They have not been admitted as yet. Again, that's why I say that could shift over time.
Okay, thank you, Mr. Chairman.
Gentleman yields back. The chair will now recognize the gentleman from Michigan, Mr. Conyers.
Thank you, Mr. Chairman. Welcome, Mr. Director. Tell me, what is the Immigration Services doing to ensure that the Deferred Action for Childhood Arrivals renewal applications are adjudicated in a timely fashion so that young people don't suffer some of the grave consequences we've heard about?
That is an important question. We did have some circumstances early on because of delayed applications, because of issues related to either errors in applications, background checks, where some individuals were not being approved prior to the expiration of their deferred action. We have taken a number of steps to ensure, especially for those individuals who actually apply on time, that we are able to finish adjudicating those applications before the expiration. So what we've done is, first of all, we have extended the time at which we give them initial notification of the fact that they're coming up for renewal. We now do it 180 days before expiration rather than 150 days. We have accelerated the time in the cycle when we begin adjudicating issues that we find with applications, be it if there are, for example, criminal history hits that need to be analyzed, or if there are errors in the application. We're doing that earlier in the adjudication cycle than we used to, and we have engaged in extensive engagement with community-based groups to make sure that individuals understand what they need to do in order to be ready for us to be able to adjudicate the case in a timely manner. And those are examples of two among a number of steps that we've taken. In fact, we've seen considerable improvement, and I believe all but about a fraction of 1% of cases are now adjudicated within 120 days of application, and I believe roughly 90% prior to expiration of those cases. So we're doing
I'm
pretty
happy
well.
to hear that. Let me turn to the subject of Haitian family reunification parole. This program has a potential to help many more Haitian families, and I want you to tell me what you see as challenges involved in expanding Haitian family reunification parole program to include all of the Department of Homeland Security approved Haitian beneficiaries and not just a small subset.
Again, I think, as you know, generally parole is a tool. It is a kind of relief that we use on a case-by-case basis, either where there is a humanitarian reason or whether there is a significant public interest. What we've done in the Haitian case is created parameters in those cases for individuals who are who have a qualifying family relationship, who are within a certain horizon prior to the ability to adjust. That, for us, in designing that policy, seemed to be the right parameters to put on that case. In fact, that has offered relief to a number of individuals. But we can certainly continue to engage on ways that we can possibly improve that program. We certainly know that Haiti, in particular, is a country that has had great difficulties in recent years. The reason we have the policy altogether is because we believe that it is in the interest of the United States to help Haiti and the Haitian people get back on their feet. So we can certainly continue to engage on that topic.
And let me close by asking you about, since with reference to Syrian refugees, since USCIS holds responsibility for conducting in-person interviews with refugee applications to determine eligibility, how can it do so in a manner that most appropriately assesses for potential threats?
Thank you for that important question. Our officers are, first of all, are extremely, many of them very experienced. The ones who are sent to work in those particular groups of cases are among the most experienced. They are briefed extensively, both from classified and non-classified sources, on country conditions within Syria. They have benefits of prior interviews conducted of those individuals. They have the benefits of the background checks conducted of those individuals. Those all provide very strong tools for those individuals to conduct a thorough and intensive interviews to identify possible bases of inadmissibility.
Thank you, Mr. Chairman. And may I ask unanimous consent to have my statement on this subject entered into the record?
Yes, sir, without objection.
Thank you.
Gentleman yields back. The chair will now recognize the gentleman from Iowa, Mr. King.
Thank you, Mr. Chairman. Director Rodriguez, I thank you for coming back second time in within a month's period of time to testify to us here today. I was listening to your earlier testimony and was interested in a statement that you made. Violent criminals can come from just about anywhere was the summation of that, although there was a little more detail in your statement, as I recall. And I'm curious, that statement, I don't have any doubt is true, but is there a higher incidence among those violent criminals? Let's say, for example, are they more likely male or female?
I take the cases as they come. I don't screen based on whether people are men or women or where they come from, because the point is just about everybody can be a bad guy. You've
been in law enforcement for 25 years and you don't have a judgment on whether they're more likely male or female?
I have seen male violent criminals, female violent criminals. That's the point I was trying to make. They can be just about anybody.
We recognize that, and I recognize that in my first sentence to you, I believe. But could we establish here that there are more male than female that are committing violent crimes?
I speak to my job as a law enforcement officer. When people commit violent crimes or have histories that disqualify them from particular benefit, we do our jobs.
Can we recognize that the population of our male prisons are substantially greater than the populations of our female prisons?
Sure.
Would that be an indicator then that...
As far as I know, that is correct.
We know that's correct.
Yeah.
And so wouldn't that be an indicator that males commit more crime and likely more violent crime and more homicides than females?
Sure.
Okay, so it took us a little while to get to that, and I'm thinking it's going to be a little harder to narrow this down a little more. Is it against the law to profile?
It is certainly based on race. For example, based on national origin, it is against the law to profile.
Against the law. Could you cite the laws that prohibit law enforcement from profiling?
I couldn't specifically cite it. It's based on case law. It's based on it's based on constitutional case law.
Not on statute.
That I'm aware of, there's certainly not a federal statute that prohibits that.
So as law enforcement officers, are you prohibited from looking for a person based upon a profile?
You can, for example, if you have somebody who is suspected of a crime and there are identifiers, I think this is part of where you're trying to go, identifiers based on their race, their national origin, some other identifying characteristic about that individual, of course you're allowed to know that in order to be able to catch that individual.
And it could be multiple identifying characteristics.
Sure.
It could be height, it could be skin color, it could be sex, it could be clothing, it could be a vehicle they drive. It could be patterns that they have.
Patterns of behavior.
Patterns of behavior.
The bar they go to, I guess, is sort of the example you might be going to. Sure.
And then if we happen to see that criminals are coming out of that, I've just described a profile, by the way. If we happen to see that criminals are coming out of that profile, are you prohibited then to give greater scrutiny by law to that profile that is consistently coming back to us as the most likely profile of a violent criminal?
Again, I think as a matter of criminal investigation, I think this principle applies to anti-terrorist investigations. You go where the activity is. So I don't think that's based on what race the person comes from, what national origin a particular group comes from. You go where the activity is.
Okay, but we would also know that if we, and I'm not going to speak to this specifically, but when we walk through prisons, we get a pretty good idea of the makeup of the prisoners there, and you can't walk out of there with not have some ideas about where you're likely to find crime on the streets in America. Would you agree with that?
I think that's a fairly complicated topic, actually, Congressman.
Okay, we got to this place here less than a month ago, too, and I wondered if you went back and reviewed a couple of federal sections of code, 1101 and 1158, that require that you consider the race, the religion, the nationality, the membership in a particular social group or political opinion as a factor and when you do the background checks on individuals that are applying for asylum?
Well, those are the bases for either asylum or a refugee claim. Would be persecution based on membership in those categories.
Okay, but last time you said that you don't inquire as to religion. Have you had a chance to reconsider?
And I have to be clear. We actually, I misspoke. We actually do inquire as to religion as part of the interview. That may be relevant to many elements of the claim.
Thank you. I'm glad we got that clarified, and you had an opportunity to do that. And then, do you recognize that there are Muslims who are persecuted because of their religion?
Without a doubt, yes.
Okay, and there are Christians that are persecuted because of their religion?
Without a doubt, yes.
And that there are applications for asylum in both of those categories. It's curious to me when I look at the report from 2015 from Syria, 1,573 Sunni Muslims admitted under that, and 29 Christians. That would seem to be very disproportionate to me when I look at the pictures, the film, and go over there and see the numbers of victims that are displaced and persecuted in a population of Assyrian Christians that was something like 2 million, now down under 400,000. We could only find 29 out of that group, but we found 1,573 Sunni Muslims. So I'd ask you to consider the religion in perhaps a different light than you might be. And
Appreciate that feedback. I will certainly let you know that we have, both in Syria and in Iraq, we have screened and admitted refugees, not just Muslims, but from a number of other religious minorities, including Christians. As I understand it, Christians represent about 1.3% of the cases seen by UNHCR. So we are part of what the proportions that you're talking about reflect. Is the population of who's in Syria. Last I checked, barrel bombs don't discriminate.
We're the UN's regulator, and I've run out of time. I thank you, and I yield back.
Gentleman, Iowa yields back. The chair will now recognize the gentleman from Illinois, Mr. Gutierrez.
Thank you. Good to see you, Mr. Director. Thank you for coming and joining us and for your service. So I won't try to figure out if you're discriminated against Christians or Muslims who you're showing some preference for. I think that's another hearing here, or how many people are. I would like to ask you about the new guidance on the 3 and the 10-year bar. How far are you along to implementation of that new guidance, given that one of the most infamous and onerous impediments to legal immigration was changing the law in 1996 here with the 3 and the 10-year bar. Before that, there was no 3 and 10-year bar. Where are we along the way on giving guidance, new guidance?
And Congressman, I share your views about the importance of that guidance. There was a clear lack of understanding as to the definition of extreme hardship as a basis for a waiver from those 3 and 10-year bars. The draft guidance that we issued, I guess a couple of months ago now, was meant to bring clarity to that purpose. We opened it for comment for 45 days. I will tell you that we received a number of productive comments that we think we will be incorporating into the guidance. That comment period is closed now. So we're in the process of incorporating the comments that we got.
How much longer do you predict?
I would
forecast?
venture, again, without being able to be exactly specific about it, just a very small handful of months before we'll be ready to issue that as final.
And then who exactly is going to receive this guidance? What's the name of this officer within your your service that's going to receive this guidance?
They will be immigration services officers.
Immigration
on my
services
staff. We will
officers.
also, of course, make it public. We will take steps to train the staff that will be adjudicating those cases so that they understand not just what the guidance says, but how to actually, how to use it. And also we will...
How many of these officers exist?
Well, I think, as you know, I have thousands of officers.
We have
that work in my
thousands
office.
of
Yeah,
them.
what I can't tell you right now is who are the eligible, how many of those are eligible receivers for those kinds of cases.
For those kinds of, but we have thousands of them that could be eligible. But this isn't, they're not, they just don't only determine the 3 and the 10-year bar, they determine a wide variety of stuff, of things.
That is correct. I would guess that we will have, you know, sort of particular groups of officers
That's
who
where
are
I would,
working on these cases.
you must just be able to read exactly what's happening.
It's been said, Congressman.
Yeah, you're good. That's why I thought, since it's new guidance, they're using the old guidance, right? And you're giving them new training, we might, and there's thousands of them, and you don't need thousands of them to do the 3 and the 10-year bar. You can pick a group of people. You might want to train a group of people.
Yeah, I mean, it's curious.
So that we know who the 3 and the 10-year bar guy is that's been trained, or woman.
We, again, I'm not exactly sure who we're going to pick as the eligible sort of group of receivers for those cases. I will observe this. My guess is that the volume of those kinds of applications will go up
Okay.
now that
But that's-
there's more clarity. So-
Now that there's more clarity, and just for my friends on the minority and majority side, I think this is important because this could help us 15, 20% of the 11 million undocumented with no action of the Congress of the United States through the sponsorship of an American citizen or permanent resident that is eligible to sponsor them, could get their undocumented status cleared up. Guess what? We could start doing the work that America sent us here to do. So I think it's a very important job. Secondly, because my time's running out, we got 40 seconds more. So historically, people become citizens. There's an uptick in citizenship application when 3 things happen. A, you guys increase the price, so people want to get in before there's an increase in price. That's not happening on citizenship. But there are 2 other things that historically we've seen increase people's participation in becoming citizens. And since 6 of the 8 million are Mexican nationals that are eligible to become citizens, this is particularly important to a group of people that have been called murderers and rapists. It's very particular to them that they could become citizens at this particular point. So the other 2 factors are an election and they feel under attack. Well, the feeling under attack, I think even the majority would probably say, yep, that one, they're under attack. And there's an election that they can use to respond to that attack. That has been traditionally. Are you ready for what I expect to be hundreds of thousands of permanent residents who can be, if the past is any indication of what you're going to confront in the coming months? Are you ready for that uptick in citizenship applications as we get ready to go into 2016 and those permanent residents legally admitted to the United States who feel under attack and want to participate get to participate?
I would add to the drivers the fact that we're also engaged because there are 9 million legal permanent residents, many of them now for a very long time, in a very active process of promoting civic, linguistic, and economic integration of legal permanent residents. So we think that too will drive people, and the answer is yes, we're ready.
So in addition to the 2 that I gave that will be drivers, there's the 3rd.
We are, and one of the
You
things
guys
that
are
we
out
focus
there
on-
engaging the community civically.
We are, and because of the importance of naturalization in particular, we have made sure to bring those processing times in line with target. They are at target.
My time is up, and the chairman's so good. I just want to make sure that everybody knows we're out there teaching them English, the Constitution of the United States, and getting them ready to be American citizens, and nobody can be against that. Thank you.
Gentleman yields back. The chair will now recognize the chairman of the full committee, the gentleman from Virginia, Mr. Goodlatte.
Mr. Chairman, thank you, and with your permission, I will give my opening statement, and then if time allows after, and all the other members have asked their questions, I'll
Permission
questions
granted.
of Director Rodriguez. So, Director, your appearance before this subcommittee comes at a time when Americans are feeling increased concern about the security of our nation, and in particular about the way U.S. immigration policy is being exploited by those who wish to harm this country's citizens. Quite frankly, Americans do not believe that their interests are being put front and center when it comes to decisions about whether or not to issue an immigration benefit to a foreign national. And your agency has the responsibility to show a commitment to reversing that belief. Today, I hope you can convince us that the USCIS is in fact putting American interests first. But I'm dubious given recent events, immigration benefits data, decisions by your agency, and even your own written testimony. At the beginning of your testimony, you give the slightest nod to, quote, safety and security, end quote, one small part of a sentence, in fact, and then launch into an unabashed commitment to your top priority of implementing the President's executive actions on immigration. As you know, I and many Americans believe that such executive action is unconstitutional. It's a usurpation of Congress's plenary power over immigration law and policy. And despite the outcry to that effect, your agency continues to approve deferred action for childhood arrivals applications with a denial rate of only 6.5% out of nearly 700,000 approvals. But there are many other reasons that my constituents and I do not have confidence in the USCIS. For instance, when the General Accounting Office finds, as it did in a scathing report released last week, that USCIS has very limited fraud training for asylum officers, that USCIS doesn't regularly assess fraud risks, and thus doesn't have in place mechanisms to mitigate fraud, and that even when random reviews of asylum cases to assess whether the cases are being adjudicated correctly are conducted, fraud is not considered. The fact that the USCIS approved for a K visa a radicalized Islamic extremist who went on to murder 14 Americans and injure many more does not exactly instill confidence in the work that the USCIS is doing. The fact that my staff was told that there were no plans to review previously approved special immigrant juvenile cases in light of suspected rampant fraud brought to light by a news organization's superior investigative work does not instill confidence in the work that the USCIS does. The fact that USCIS issues policy memos determining that individuals initially classified as unaccompanied alien minors can continue to pursue UAM status despite the fact that they subsequently live with their parents doesn't instill confidence. The fact that despite valid concerns about the vetting of refugees raised by members of Congress, the American people, and even the Federal Bureau of Investigation and intelligence officials within the administration, USCIS simply tells us not to worry, the vetting process is good enough, doesn't instill confidence. The fact that the USCIS keeps abusing what is supposed to be its limited discretionary parole authority to create new classes of foreign nationals eligible for parole in the United States, despite Congress's unwillingness to do so, doesn't instill confidence. The fact that there continues to be a seeming rubber stamping of credible fear claims for the record high number of individuals surging across the southwest border doesn't instill confidence. And the fact that sources tell us that USCIS is considering making it easier for individuals with DUI convictions to get DACA doesn't instill confidence. The American people are not impressed with paying lip service to security and anti-fraud measures in written testimony to Congress. They deserve action ensuring their safety and security. I appreciate your appearing before the subcommittee and look forward to asking you some questions to follow up on these comments that I've made so that you can assure me, despite all that I've outlined and the numerous examples I've yet to outline, that the USCIS is putting American interests first. I yield back, Mr. Chairman.
The gentleman from Virginia yields back. The chair would now recognize the gentleman from Colorado, the former federal prosecutor, Mr. Buck.
Thank you, Mr. Chairman. Good afternoon, Mr. Rodriguez.
Nice to see you, Congressman.
I wanted to ask you, how did Ms. Malik get into the country? how did she slip through the procedures that you have?
Again, I am constrained, given, one, there's an ongoing law enforcement investigation, and two, existing policy and law with respect to alien files. I am constrained from talking about an individual case.
Okay, I guess
Certainly
I want
describe the
to,
process.
you were a former prosecutor,
Yes, sir.
and I was a former prosecutor also. I didn't specialize in prosecuting dead people. I'm wondering why you can't talk about someone's application after they have been killed or after they've died.
Again, without speaking to the specific case at hand, there is, without a doubt, there is a law enforcement investigation that is ongoing right now.
Well, there are a lot of law enforcement investigations going on right now throughout the country, but what information, how does information on her application that you would have examined or that your agency would have examined implicate a federal investigation?
That our practice is, when there is an ongoing law enforcement investigation, and when we're talking about whether an alien file, that we don't talk about specific cases in public. So those are the constraints that I'm under, Congressman.
Okay. What have you learned from the fact that your agency allowed someone into this country who ended up participating in a mass killing? What changes has your agency made to its procedures?
We are in the process right now of, at the directive of the President and the Secretary, of reviewing both cases, the K-1 cases in the last 2 years, and also overall looking at our procedures. One couple of issues that we have identified. Remember, we're in this process at two different points. We are at the petition stage, when a U.S.-based petitioner is filing a petition for an applicant who is abroad. At that point, our only authority given to us by this Congress is to adjudicate the bona fides of the application. If there are inadmissibilities at that point, we don't have authority at that point to do anything about it.
Well, what authority would you like to have?
Well, that's, I think, a discussion that we can have going forward. We can give.
Can we have it
technical
today
assistance to this
in
Congress.
2 minutes and 1 second?
We can give technical assistance to this Congress. I'm identifying a particular gap that we've seen.
Did you do anything in terms of developing a profile on this particular individual that would help you in your determination of whether other individuals should come into the country?
I'm sorry, Congressman. I know your time is short. I don't think I understood the question.
Sure. Did you do anything? We all understand what happened in San Bernardino, and you know who did it, and you had information on this individual that you can't share with us. Did you look at that information and make any changes to your background checks and what information you need and what information you'd like before admitting somebody into this country?
We are weighing changes now, and are also looking to see what other changes we may want to make.
What are you weighing?
Right now, I can't speak more specifically than that, other than to see if there are enhancements to background checks, not just in K-1, but possibly in other areas. The points at which we do those background checks, those are among the kinds of issues that we're looking at.
Okay. Mr. Chairman, based on my inability to get any specific information that's helpful, I will yield back.
Gentleman yields back, and I'm sure the gentleman's frustration is fueled in some part, not because of this witness, but it's the director of the FBI himself who has given us some of this information. For instance, I read today that the female terrorist was radicalized years before her application. That came from the director of the FBI. So I'm not blaming today's witness. I'm sure he's doing exactly what he was told to do, but you can't cherry pick certain information and share that with the public and then hide behind an ongoing investigation and expect to be taken seriously. But that's not a reflection on today's witness. With that, the gentleman from Idaho, Mr. Labrador.
Thank you, Mr. Chairman, and thank you, Mr. Rodriguez, for being here today. I want to start with the affirmative asylum process. You're no doubt aware of the December 2 GAO report regarding fraud in the asylum process, and I'm sure you were just as troubled as I was by the ultimate conclusions. I noticed that there is significant backlog in affirmative asylum adjudications that linger way beyond the established timetables for adjudications. Can you provide this committee with the exact number of cases currently pending adjudication for over 180 days?
I can't provide that specifically, other than to acknowledge that that number is significant. I can assure this committee that we are working as fast as we can to hire up asylum officers so we can move those caseloads. I also have some things I'd like to say if the opportunity presents itself about the GAO report.
Is it your testimony that this is solely due to the lack of resources, that the delay is solely due to the lack of resources?
We've certainly seen a significant increase in the volume of asylum cases, and so it has necessitated an increase in resources to process those cases.
While adjudication times are important to keep the process moving, I'm concerned that the GAO found that there was no enterprise-wide fraud risk assessment completed by the agency. I could understand a delay in adjudications if such a fraud assessment was underway. Can you explain why USCIS has not completed such an assessment?
I would say that we are taking a number of steps based on the findings that the GAO made. We are adopting most of the recommendations that they have made. I would also indicate the fact that there have been a number of prosecutions for asylum fraud which resulted from our asylum officers identifying those cases as fraud cases. So I to some degree take issue with certain omissions in the GAO report. We are embracing its recommendations. We think it'll make our work better.
So do you believe that fraud is a pervasive problem in the asylum context?
I believe that it is something that we need to do everything we can to prevent. I certainly perceive it as
obviously we need to do
risk.
everything we can to prevent it, but is it a pervasive problem in the asylum context?
Again, I view it as a risk. I'm not sure that I would agree that it is a, quote, pervasive problem. I view it as a risk that we need to safeguard.
So how many asylum cases are being granted in the United States right now, percentage?
I believe it's roughly 25,000 in recent years.
So what percentage is that of the adjudicated cases?
I couldn't tell you specifically what percentage it is. I can certainly get you that information.
Okay, based on USCIS internal investigations and audits, does the agency have an estimated percentage of the number of fraudulent asylum applications that are affirmatively filed each year?
Again, we know the cases that we found, and that's why I point to the cases where our asylum officers detected fraud and flagged those cases. We can certainly get you a number of cases where we've specifically identified fraud.
Can you get us a percentage?
Yeah, we can. We can give you a briefing on what we know about the sort of the, quote, pervasiveness of fraud in our cases.
Are asylum officers given the training and resources necessary to detect fraud?
They are, and in fact, they have. They have detected fraud.
Do you believe that the 35 fraud detection and national security officers embedded at asylum offices nationwide is sufficient to combat the fraud in the process?
That represents, as you know, a doubling of the number of fraud detection national security officers assigned to the asylum. I think that has permitted them to provide extensive, much greater support to the asylum officers. We're obviously going to continue evaluating whether that is enough, and if we need to increase the number, we'll increase the number.
Do you currently believe it is enough?
I have no reason to believe that it's not enough.
But what other steps is the agency taking to address this issue?
The main issues is to continue to train our officers and to make sure that they're getting the resources they need to combat fraud.
I yield back my time.
Gentleman, Idaho yields back. The chair would now recognize former U.S. Attorney from Texas, Mr. Radcliffe.
Thank you, Chairman Gowdy. Director Rodriguez, I want to follow up on a point raised by Chairman Goodlatte in his questioning to you, and it was about your stated testimony that your top priority is to implement the President's executive action on immigration. I know you're a former prosecutor. I am as well. We both took an oath to defend the Constitution. I was one of the first folks who questioned the constitutionality of the President's actions in that regard. And while that certainly may not matter to you, I think what should matter to you is the opinion of a federal judge followed by the opinion of a Federal Circuit Court of Appeals, which ruled that the constitutionality of the President's action still remains very much in doubt. And so for you to make, what would appear to be a highly questionable, likely unconstitutional action of the President your highest priority is troubling for me. This is especially true when there's very little doubt that it was the President's action in that regard regarding executive amnesty that was the catalyst for the 2014 surge of unaccompanied alien children across our southern border. And even though the courts have now issued an injunction on the President's amnesty, the belief in other countries that you can still simply show up here in the United States and be granted amnesty and legal status is very much a pervasive belief in those countries. And accordingly, we are, as you know, still seeing a continued rise in the influx of unaccompanied alien children. According to the Department of Health and Human Services, in just the past 2 months, the number of unaccompanied minors crossing into the United States is 10,000 in just the last 2 months. That's a spike in activity, and I know this is a fact because HHS contacted my office to let me know that as a result of this dramatic increase, they're going to have to open additional facilities to handle the influx. And 2 of those facilities are going to be in Texas and are going to open on Friday. And one of those facilities is going to open on Friday in my district, in Royce City, Texas. So to be clear, we certainly didn't advocate for this, and we didn't support the policies which have been the catalyst for this crisis, but nevertheless, we're left with dealing with the aftermath of the President's actions in this regard, and as I hope you can appreciate, this is an issue of great concern to my constituents. So I want to ask you, the Inspector General report back in 2012 found that 25% of the immigration service officers were pressured to, in their opinion, get to yes in handling questionable applications. And I know that you were not the director back in 2012, but given that the President's executive amnesty has been put on hold by the courts, but your stated priority remains administering the President's executive actions in that regard, what assurance can you give me? I hope that you can, that presently staffers aren't being asked to approve questionable applications as a way to implement the President's intended policies in this regard.
So I'll tell you exactly what I have done. I have communicated with my entire workforce through town halls. I have visited USCIS offices throughout the world, and I have communicated very directly to my officers that the authority to make decisions about cases rests with them and with their supervisors. That my role is certainly to set policy, to set procedures, but the individual cases are theirs to decide. I have a tremendous amount of respect for my workforce. I have gotten to know many of them. I would say that all of them take their professionalism far too seriously and their oath far too seriously to be bullied by anybody into making anything other than the decision that they believe is right, based on the law, based on our policies, based on our procedures. I haven't seen the Inspector General report that says that 25% quote, feel that way. What I have seen is what I have seen being fully engaged with my workforce as its director, and I have not seen evidence of that.
Mr. Chairman, it appears my time has expired, so I will yield back.
Thank the gentleman from Texas, and the chair would now recognize the gentleman from Virginia, the chairman of the full committee, Mr. Goodlatte.
Thank you. Director Rodriguez, it's my understanding that there was a teleconference last week between the Refugee, Asylum, and International Operations Division and USCIS office personnel regarding refugee processing. And on that call, the Deputy Associate Director of RAIO, Jennifer Higgins, told the field office personnel that as refugee pools decrease in places from which we have resettled many refugees in recent years, like Malaysia and Nepal, our real focus is going to be in the Middle East, Jordan, Turkey, Iraq, Russia, Kenya. Is what Director Higgins said true, that in the next few years, essentially the bulk of refugees will be coming from places like Jordan, Turkey, and Iraq, places where we know security is of great concern?
Chairman, I'm not going to be able to comment on internal deliberations, but let me answer the main question that you're asking. It is, in fact, that there are certain refugee streams that we've been seeing in recent years where basically they are drying up. I don't know that I would necessarily have used that phrase, but where the cases are essentially slowing down. At the same time, the Syrian example speaks for itself. You have 4 million applicants for refugee status in Jordan, Lebanon, in Turkey. They are coming from a country that is absolutely devastated, more than half of its population displaced. The President has been clear in his directive to us that we admit at least 10,000 people from Syria in this fiscal year, along with an overall target of 85,000. We've been very public about that, about those goals. So yes, we are perceiving that in certain places the refugee streams are drying up, where in fact they're increasing from other countries.
And it doesn't concern you that there might be security issues in some parts of the world, that it is more difficult to vet the refugees?
Oh, of course it concerns me, and that's why a big part of what I've dedicated myself to is to digging into our security vetting process, observing our officers in action, visiting them on site, which I've already done. I traveled to Turkey back in June. I've had engagements with my refugee officers, with my asylum officers as well, to assure myself that we are in fact deploying what we have described, and I now believe correctly, as an intensive, multi-layered process to ensure that refugees deserve the status.
Let me interrupt, because I'm going to run out of time and we got votes on the floor. Would it be acceptable for a USCIS asylum officer to grant asylum in cases that they suspect fraud?
I think when we if we suspect fraud, then we need to chase down that issue.
What changes do you plan to make regarding asylum processing procedures, given that asylum officers in 7 out of 8 asylum offices the GAO spoke with told the GAO, quote, that they have granted asylum in cases in which they suspected fraud?
We are enhancing our training. I am engaging with my workforce so that I hear those concerns directly, not just laundered through reports. And we will continue to support our officers, both in training.
Support
and also
or admonish them to change their practices?
To support them.
And to continue to approve cases where
What
fraud
I
is
said,
suspected?
if they suspect fraud, then those issues should be chased down.
In May of 2013, the USCIS issued a guidance memo regarding asylum applications filed by unaccompanied alien children. I have heard from several immigration judges that this memo is problematic. One of the end results is that an individual initially classified by DHS as a UAC can continue to benefit from the UAC status despite the fact that they actually live with their parents in the United States. How does it possibly make sense that an individual is classified as a UAC when the Department of Health and Human Services officials have released them into the care of a parent?
I will need to dig into that issue further, Congressman. That memo was issued before I arrived at the agency. I will familiarize myself and get.
Does that raise some
about that.
concerns to you?
Again, I need to know the facts and circumstances related to that directive.
I understand that the fraud detection and national security officers conduct open source research on refugee applicants as part of security screening. So they check to see if there is evidence that an event that the applicant claimed has occurred, as evidence in support of a refugee claim actually did occur. But isn't it true that with open source checking, an applicant could simply describe an event that he or she has heard about or has knowledge of, and that it really doesn't prove the individual was present at the event?
I'm fairly confident that my fraud detection national security officers are looking at a whole lot more than open source information when they're checking claims by our applicants.
Well, I wonder if you could give us a comprehensive description of what it does mean to use open source, number one, and number two, what in addition is done when open source, in some instances, seems to be the only thing they cite as the basis for approval of the claim.
I mean, again, depending on the facts and circumstances, I could see where the open source does not raise the concerns that you're talking about. I also know, however, that our officers look to classified, confidential, secret sources as well as part of our vetting, as part of their evaluation of claims made by applicants, be it for refugee status or whatever other benefit lines we're talking about.
Thank you. And Mr. Chairman, if I might ask, when do you think you could provide those answers to the committee?
Within 2 weeks of today.
All right, that'd be very good. Thank you, Mr. Chairman. My time's expired.
Yes, sir. The gentleman yields back. Director, they have called votes. There's 6 minutes left in the vote. I'm happy to try to get the gentlelady from Texas in. I don't want to jeopardize anybody missing votes. You want to go vote? And I hate to do it to you.
I don't mind a water break.
Okay. There are 2 votes, so we'll cast both procedural votes, and then we'll come back immediately and recognize the gentlelady from Texas. Thank you.
Chairman.
We'll be in recess.
appreciate it. Thanks. Yeah. Thanks. Yeah, because I need to close the loop on that. Yeah, people, they ask good questions. Like, I wish these folks would hear my hearing last week. They do. A lot of people were, hey, I'm Tracy. By the way. Yeah, I figured we were here. But anyway, a lot of folks didn't. Yeah, I didn't show up. And this great list of questions. I think he would have been dragging, he would have been withered and dragging out of the room if he can ask all these questions. So I'm doing some cue for just to get everything off the record. So they're putting them all in those, so they'll have to respond. But anyway, yeah, he kind of skated with this last week because there was a lot of people here to kind of chew him up. But I wish like enforcement days you have adequate time. No, I haven't seen it. Okay. Well, you guys be. Yeah, no problem. Thanks for the rest of it. Yeah. Thank you. See you.
Oh, did your boys enjoy the?
Yeah, they did. Yeah, my wife get a picture of my youngest son with and he was all kind of dressed up nicely. He had a conversation. Yeah, we saw him. Got a photo with him. I hit Shelley. The only thing I didn't get was Brandon. He was moving around.
Oh yeah,
Target.
That would be great.
Yeah, and I was going to try to hit him up and do that, but he got away. I couldn't find him after.
Well, India is like Ryan's like music. And
Yeah, he loves it.
Yeah.
He's big into that. He has a set of drums, and it's just like I can hear him when I drove up from work, coming home. I can hear him in his room. He's got a great keep rhythm. He's good. He's really good.
That's cool. Well, anyway, enjoy the rest of your day.
Absolutely. Thanks.
See ya.
Teresa Waiver last Wednesday. Andrea drove me back to the Ford building at 2:15 a.m. So I went back. Did you do work? So I went back on an email and stuff. And then emailed the code. And then, so then I went to do the copies. Right. So 9 a.m.